Hello, my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about data privacy and the Computer Fraud and Abuse Act. The Computer Fraud and Abuse Act was a law that went into effect in 1986. It's actually interesting the way that it came about. It came about as a result of Ronald Reagan watching the movie War Games and being concerned about people possibly using computers to do nefarious things as it relates to crime, or in that case it was about someone doing something that could have possibly caused a nuclear war. So at that time, personal computers were not widespread in terms of use. So people have been really concerned about this particular act or this law that's been into effect. One of the things that's come up over the years as companies have tried to use this law, a lot of times is used for situations where an employee may leave the company and possibly take maybe trade secrets or some other type of information that's considered like unauthorized use by someone. That's kind of the most popular way that we see it used. But this particular act has come into play with data scraping. So several years ago, LinkedIn was in the case with a company called HiQ. And HiQ had done data scraping where LinkedIn had said it was against their terms of service for them to do this data scraping, and they had used this particular law to say that they thought it was akin to hacking. LinkedIn actually lost this case. So I guess there were two questions. One is, does this particular law apply? And the judge said it did not, so that this company could possibly continue data scraping. The question that this case did not answer was a question that's now being asked in cases with Clearview AI, and it's about a company's First Amendment right, again, to scrape public data and be able to use it for other purposes. So one of the other things about the Computer Fraud and Abuse Act that companies are interested in, or that is up for debate a lot, and it is about the definition of what a protected computer is. So when this act was put together, it was supposed to apply to financial institutions and transactions, government, and private companies in interstate commerce. So that will be within the country or outside the country. But some cases have really drilled down into what actually a protected computer is. So, for example, someone may say if you have data on a cloud platform and it's public, then regardless of where the computer is in the cloud, if the data is public, then it may not be a protected computer, which means it may not apply to this particular act. I think, this particular act has been revised a number of times to sort of expand some definitions. One of those was expanding the definition of a protected computer to be a phone, like a cell phone. But we've not yet actually seen specific things where they spell out things like cloud computing and things like that. So this particular act is very interesting. I think it's still up for debate and interpretation as to how it is going to apply to kind of new or emerging technologies. Obviously, the idea behind it is to kind of stop unauthorized use or access or something that could be detrimental to financial services, governments, or private industries that are in interstate commerce. But we will see if it gets expanded again, or there are more definitions where they can drill down to be more specific in terms of what this particular act would apply to in the future. That's it. Thank you.